we give a summary of substantial facts in terms of Section 144 of Act 51 of 1977. We are also, my lord, not going to traverse the summary of substantial facts as my colleague has already done so, and that evidence is before court. The summary of substantial facts starts from paragraph 1.1 on page 2 up to paragraph 1.5, which proceeds up to page 3. I'm sorry, 2.1. I'm sorry, 2.1 up to 2.8, which carries on page 4. Then paragraph 3 on page 4, we deal with the plea of the accused. In paragraph 3.1, we mention that the accused pleaded not guilty on the 18th of July 2023 and chose to exercise their right to remain silent and proffered no plea explanation. We mentioned, my lord, that accused number 4's legal representative added on his behalf, that is now accused number 4, that his plea is a bare denial. In paragraph 4...
What is the effect of that? Have you thought about it?
Well, the effect thereof is that all the elements are being denied, and he puts the state to the proof thereof.
Yes. Yeah, I hear you.
Yes. And furthermore, that he's not going to give any plea explanation in terms of Section 115.
Okay.
However, certain admissions were made at the beginning of the trial, and those admissions, my lord, appear in Exhibit F. The essence of these admissions, my lord, is the identity of the deceased is admitted, the necessary chain statements from conveyance of the deceased from Butsilong Hospital to the government mortuary, the people who conveyed or who handled the deceased body, the identification of the deceased, as well as the post-mortem report, but more importantly, my lord, the cause of death. So it surprises me, my lord, that Advocate Nxumalo, in his argument, says that the evidence of Brigadier Gininda differs from the summary of substantial facts when they have admitted that the deceased was killed, as well as the cause of death. We briefly, when we respond to his heads, indicate that murder is simply the unlawful and intentional killing of a human being, and we refer to the book of Snyman, wherein he defines murder, and he cautions that intention should not be confused with motive. If, as in the current instance, Mr. Senzo Meyiwa was killed, what the motive for his killing, whether it was a robbery, so-called robbery gone wrong, or Whether it was a hit, it makes no difference, my lord. A life was taken, and we submit, therefore, my lord, that argument cannot go up. As we mentioned, my lord, we will deal with that when we address the individual paragraphs
Okay.
that Mr. Nxumalo has penned in this matter.
Okay. Yeah, I didn't mention it then. When you guys made those admissions, the late Mr. Mgomezulu subsequently comes back to this court and says he's going to call Longwe,
Yes.
who will come and tell this court that he's the one who shot the deceased Senzo when he, Longwe, apparently has had a quarrel with Ms. Zandi,
Yes.
the so-called girlfriend. Are you with me?
Yes.
And yet, when you admit the cause of death, the doctor, you remember, he said it was a wound which was inflicted,
It's a contact wound.
contact wound on the skin. And here comes Mr. Mgomezulu. He comes with something different, which allegedly he is going to lead through Longwe, how the deceased Senzo died. Are you with me?
Yes.
Then I didn't mention it. I just said,
Yes.
are you with me, Mr.
Yes.
Nxumalo?
Yes.
I follow.
Yeah, because here's a flesh wound, according to the doctor. It was pressed against the skin. There's a firearm residue, blah, 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 blah. And somebody else comes and says, that's not how this guy was shot or
Yes.
came to die.
I understand, but you have
Okay.
disavowed.
Yeah, fine, all right.
Your
Okay.
assertions. Thank you.
Okay, fine.
We did address that issue, my lord, just before the close of the state case,
Okay.
when we showed the relevance of the video footage that we obtained from ENCA.
Yeah.
But my lord, coming back to the heads on page 4,
Yes.
paragraph 4,
Oh,
4.1, we mentioned that about 60 witnesses testified for the state, and that their evidence can broadly be classified in the following categories. 4.1.1, the people who were in the house when the incident happened. 4.1.2, the neighbors of the Nxumalos, Mr. Kanyashe and Ms. Itabise Mukiti. 4.1.3, the police officers who attended the scene, Sergeant Tetwa and Matebula. 4.1.4, the forensic field officers, and here, my lord, we refer to Sergeant Musia and Lieutenant Colonel Mhlahlo. 4.1.5, ballistic evidence, and here we refer to the evidence of Lieutenant Colonel Mangena, Lieutenant Colonel Sereo, Warren Santini, Grobler, and Rulofse. We refer to 4.1.6 DNA evidence. Here we refer in particular to Captain Masetla. 4.1.7, we refer to the confessions, accused 1 and 2. The pointings out of accused number 1, and also the evidence of the investigating team Brigadier Gininda, Sergeant Mohola, Mohane, etc. Then 4.7.8, we refer to the corroborating evidence. And here, my lord, we refer to the evidence of Mr. Lionel Zwane. We refer to the documentation from the Legal Practice Council regarding Mr. Mjiyako. Then 4.1.9, we refer to cell phone evidence. And here, my lord, we refer to the evidence of Colonel Stein, Colonel House, Ms. Pinky Faithillingham. In paragraph 5, we deal with the summary of the state evidence. My colleague, Dr. Sibanda, will take the court through the summary of evidence. If I can ask the court to turn to page 15, it's paragraph 6.
Page 15.
Yes, page 15.
Yeah.
Page 15, paragraph 6. There, my lord, we deal with the purpose, section 174. I think what we need to mention at the outset is that whatever ruling the court makes is that it's an interim ruling, my lord. If the application is refused, there will still be a final ruling at the end of the case. Paragraph 6.1, we refer to the work of the renowned author, career on Himstra criminal procedure, the 2008 edition. At pages 22 to 76 describes the purpose of section 174 as follows, and we quote, Section 174 creates an exception to the normal trial procedure, primarily to relieve the trial court of the burden of persisting machine-like with a futile trial when it is clear that there cannot be a conviction. The purpose is to save time and effort and not to complicate the court's task. There are jurisdictional prerequisites to be satisfied before the power arises in this manner. The court must be of the view that there is no evidence upon which a conviction can be based. Therefore, two related but distinguishable decisions have to be made. Firstly, is there lack of evidence? And if so, should discharge be granted? The former entails mainly a clinical assessment of the evidential value of the evidence. The latter requires sound judgment in the light of all the circumstances of the particular case. I don't know if Mr. Jonas would like to interpret this to go along, or must we first finish? Finish. Okay, thank you. Paragraph 6.2. In S versus Agliotti, 2011, volume 2, SSCR 437 is a decision of the South Gauteng High Court at 456, paragraph 271. The court held as follows, and we quote, in terms of section 174, there is no obligation to discharge, but a competence to do so, The court is called upon to act judicially with a sound judgment in the interest of justice. The facts and circumstances of each case dictate the route to follow. In paragraph 7, we deal with the test for application for discharge. Paragraph 7.1. Section 174 of the Criminal Procedure Act 51 of 1977 governs the test to be applied when there is an application for discharge of the accused at the end of the state case, and provides as follows, and we quote, if at the close of the case for the prosecution at any trial, the court thinks that there is no evidence that the accused committed the offense referred to in the charge, or any offense of which he may be convicted on the charge, it may return a verdict of not guilty, and we close the quotations. In paragraph 7.2, it is tried law that the words no evidence do not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. Then paragraph 7.3, whether or not to refuse or grant a discharge at this stage of the trial entails the exercise of a discretion by the trial court, and the refusal to discharge an accused at the close of the prosecution cannot be the subject of the appeal. This once more, Mala, just demonstrate the wide discretion that the court has at this point in time. And we refer to the case that my learned colleague also referred to of State versus Lubata, 2001, to SACR 703, and it is a decision of the SCA.
Yeah, that's I'm thinking while obviously different cases, different facts will apply. But in this case, I made 3 rulings. One in terms of a so-called confession of number 1, and another in respect of Mr. number 2, and the pointing out, remember?
Yes, yes.
And those are interim judgments.
Yes,
Are you with me?
yes, ma'am.
I haven't heard the version, the material version on the merits. Am I correct, or I'm just mad?
Yes, well, it is indeed so, ma'am.
Yeah.
And that is the point that we want to buttress, that there's no evidence under oath at this point from, as far as the merits are concerned,
That's correct.
from any of the accused.
It's different if, in my mind, it's different if I've made a ruling already, a final ruling,
Yes.
concerning those confessions and the pointing out. But here, they are hanging in the air.
Indeed, my lord. And
Okay, fine, you heard me.
if we were at the end of this state case, it would have been a different kettle of fish, my lord.
Okay.
And paragraph 7.3, the test is well known, one of inquiring whether there is evidence which, if believed, a reasonable person might convict. And we refer further to the work of Detoy on commentary on Criminal Procedure Act, pages 22 to 121. The court held as follows in the SCA in Lubata's case, and we quote, clearly a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation at some stage he might incriminate himself. that is recognized by the common law principle that there should be reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated, and the constitutional protection afforded to dignity and personal freedom. These are the passages that my learned friend referred to yesterday, section 10 and 12 of the Constitution. It ought to follow that if a prosecution is not to be commenced without that minimum of evidence, so too should it cease when the evidence finally falls below that threshold, and that will preeminently be so where the prosecution has exhausted the evidence and a conviction is no longer possible except by self-incrimination, and we have bolded those portions. A fair trial will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12. The same considerations do not necessarily arise. However, where the prosecution's case against one accused might be supplemented by the evidence of a co-accused, and we've bolded that portion, the prosecution is ordinarily entitled to rely upon the evidence of an accomplice, and it is not self-evident why it should necessarily be precluded from doing so merely because it has chosen to prosecute more than one person jointly. The accused are charged on the basis of conspiracy, and the application for discharge ought to be refused on this basis as well. Then in paragraph 7.4, we refer to the case of R versus Mlambo, 1957, volume 4, SA 727, the decision of the appeal court, wherein the court held that there is no obligation upon the Crown to close every avenue of escape which might be said to be open to the accused. Then at page 737, paragraphs F to H, deals with the argument that proof beyond a reasonable doubt requires the prosecution to eliminate every hypothesis which is inconsistent with the accused's guilt, or which, as it is also expressed, is consistent with his innocence. The court, per Justice Malan, rejected this approach, preferring to adhere to the approach which at one time found almost universal favor and which has served the purpose so successfully for generations. This approach was formulated by the learned judge as follows at page 738 A to C, and we quote, "In my opinion, there is no obligation upon the Crown to close every avenue of escape which may be said to be open to an accused. It is sufficient for the Crown to produce enough evidence by means of which such a high degree of probability is raised that the ordinary reasonable man, after mature consideration, concludes that there exists no reasonable doubt that an accused has committed the crime charged. He must, in other words, be morally certain of the guilt of the accused," close quotations. And we mentioned in paragraph 7.5 that it must be borne in mind that the credibility of witnesses is not a consideration at this stage, unless the evidence is of a poor quality, and we refer to the same case that my learned friend referred to of State versus Mpet and others, 1983, volume 4, SA 627, the decision of the then K Provincial Division at H, at page 263A, the court held that credibility would play a very limited role and the evidence ignored only if it was of such a poor quality that no reasonable person could possibly accept it. My learned friend argued yesterday that the evidence of Mr. Constable Zungu should be rejected, but we submit, my lord, that firstly, my lord, that his credibility plays no role unless it can be demonstrated that his evidence ought to be rejected in total. The court held as follows, and we quote, "At the close of the state case, when an application for discharge has been made, the sole concern is the assessment of the evidence, and credibility is a factor that can be considered at this stage. However, it must be remembered that it is only a limited role that can be played by credibility at this stage of the proceedings." And we bold the next paragraph. "If a witness gives evidence which is relevant to the charges being considered by the court, then that evidence can only be ignored if it is of such a poor quality that no reasonable person could possibly accept it. This would only be in the most exceptional case where the credibility of a witness is so utterly destroyed that no part of his material evidence can possibly be believed. Before credibility can play a role at all, it is very high degree of untrustworthiness that has to be shown. It must not be overlooked that the trier of fact are entitled, whilst rejecting one portion of the sworn testimony of a witness, can accept another portion. And we, in paragraph 7.6, we respectfully submit that Constable Zungu's evidence regarding how he observed all the accused at the Basotho hostel before and after the incident, describing in detail what each accused did, said, the clothes they were wearing, and the remark by accused number 1 that Mr. Senzo Meyiwa has died before his death was publicized in the media, cannot be ignored or be said to have been utterly destroyed in cross-examination. And we therefore submit that the application ought to be refused for this reason alone. And paragraph 7.7, we refer to the case of R versus Dladla and others, volume 2, essay 921 at 923 F to G. The court held as follows, that, and we quote, "The credibility of a witness is not a matter to which a judge may pay regard to when considering an application for discharge at the close of the Crown case. His sole duty at that stage is to consider whether the evidence advanced by the Crown, if believed, might be sufficient to satisfy reasonable men acting carefully that the accused is guilty of a crime covered by the indictment under which he is charged. Whether the evidence should be believed or rejected is a matter for the triers of fact to consider at the appropriate time." And we close quotation. And we make the submission that the evidence against accused number 4 is sufficient to sustain a conviction and that the application ought to be discharged. Then paragraph 8, we deal with the extra curial statement of accused number 2, which implicates accused 3, 4, and 5. In England, they use the term out of court statements. Paragraph 8.1, we mentioned, my lord, that accused number 2 made not one confession, but 2 confessions. One before a commissioned officer, Lieutenant Colonel Rapadu, on the 19th of June 2020 at Moroka Police Station, and the second confession before Magistrate V. Cronje at Boksburg Magistrate Court on the 24th of June 2020, in the presence of a legal practitioner, Mr. Mjiako, who was an attorney at the time, and in the latter confession, he starts the confession by mentioning that he worked in Carltonville in 2014. This fact, my lord, is corroborated by his clocking records, Exhibit DD, and the evidence of the HR manager, Mr. Miller, who has testified in this proceeding. So, my lord, there's that safeguard of the truthfulness of what accused number 2 says. It is a fact that he works at the place mentioned in the confession, namely Carltonville mine, and he did take the police officers to his place of employment. On paragraph 8.2, he states further in the confession that he received a call from Sifiso Ntuli, who is accused number 5, to come to Basotho Hostel after accused number 5 had obtained his number from Muzi, accused number 1. He proceeded to Basotho Hostel, and Sifiso, accused number 5, called him to a room where in Muzi, accused number 1, and Sifiso, accused number 4, where accused number 5 then told him that there was a job to be done that evening. Then in the confession to Lieutenant Colonel Rapadu, he said that he was briefed that the person to be eliminated or killed was Senzo Meyiwa, and that the matter was initiated by Kelly Nxumalo, who was going to make payment for the whole job. Maphisa, accused number 4, was to be positioned outside as a backup. Surveillance was then conducted. They were initially in the room of accused number 1 and later proceeded to the room of accused number 5, where they were joined by accused number 3, Karos, and Ntokoziseni Maphisa, accused number 4, who is now applying for Section 174 discharge. 8.3, he mentioned further in this confession to Ms. Cronje that Karos, namely accused number 3, and Ntokoziseni Maphisa, accused number 4, called Kelly Nxumalo. They told her that they were ready. They all left in a Polo Vivo driven by accused number 5. It was himself, that is accused number 2, Karos, accused number 3, Ntokoziseni, accused number 4, and Muzi, accused number 1. And to Lieutenant Colonel Rapadu, he said it was on a Sunday between 1900 hours and 2000 hours that Ntokoziseni Maphisa, accused number 4, Sifiso, accused number 5, they came across another Polo Vivo driven by one Simpiwe, that they all alighted except himself, that is accused number 2, Simpiwe gave Mtokozizeni, accused number 4, 2 firearms. They then left for forceful arrest and proceeded to the address. A call then came through to Karos, accused number 3, presumably from Ms. Kelly Nxumalo, in paragraph 8.4. Accused number 3 called the accused 1, 4, and 5, to outside the vehicle, and they had a meeting. Mtokozizeni, accused number 4, then took out a firearm and gave it to Karos, accused number 3. Muzi, accused number 1, had his firearm. He, that is accused number 2, also had a small firearm that was given to him in the vehicle. Then paragraph 8.5. Karos, accused number 3, said they must all be positioned as they were going to hit Senzo Meyiwa. They all got out of the vehicle, which was driven by Sifiso, accused number 5, to Lieutenant Colonel Rapadu. He says accused number 4 gave a firearm to Karos, accused number 3. Then Muzi, accused number 1, was the lookout. Maphisa, accused number 4, went to stand by the window. The T, that's now accused number 2, and Karos, accused number 3, were supposed to get into the house. When they got into the house, he, that is now Karos, pulled out a firearm, ordered everyone to lie down, and demanded money and a cell phone. In the confession to Lieutenant Colonel Rapadu, he said that Karos, that is now accused number 3, shouted in isiZulu, "Panzi, Mali, ne my cell phone," close quotations. And the court will remember that's exactly what the witnesses who were in the house testified. So what he says in what number 2 says in his confession, my lord, accords with the evidence of the people who were in the house. Once again, that demonstrates the high degree of probity of the confessions. Then Karos, accused number 3, gave him a phone and a plastic bag with money. We know that cell phone belonged to Ms. Kelly Nxumalo was robbed. Hence, there is a charge that pertains to that. To the confession to Lieutenant Colonel Rapadu, he says that he's the one who collected money and cell phones. So once again, my lord, this accords with the objective facts, and we have heard the evidence of Ms. Pinky Fathillingham, which shows that the cell phone that was robbed made contact with Muleleki Tower. 8.6 says, Senzo stood up to Rapadu. He said Senzo jumped at Karos, and there was a scuffle between him and Karos, that is accused number 3. We know, my lord, all the witnesses have testified that there was a scuffle. How could accused number 2 have known about this fact if he himself was not in the house? So once again, my lord, we see the safeguard as to the reliability of his confession. It says Karos, that's accused number 3, fired 2 shots. This once again accords with the evidence of the ballistic expert, Lieutenant Colonel Mangena. The second shot hit Senzo, but he did not see where Senzo was hit. He, that is accused number 2, left the house as Senzo was falling, and he ran out of the house to the car. He says when he ran out of the house, Mtokosizeni Maphisa, that is now accused number 4, came in. They, that's accused 3 and 4, remained in the house. Muzi, accused number 1, was standing outside. And when we deal with the evidence of Makaleni, we'll just briefly touch on that. It says they all came back. That accused number 1, Muzi was in front. Mtokosizeni Maphisa, accused number 4, and Karos, accused number 3, behind him. They drove away from the scene and drove to the hostel and went into a room. Mtokosizeni, accused number 4, asked Karos, accused number 3, "Are you sure you hit him?" Then Karos, accused number 3, and Sifiso, accused number 5, ordered him to go to the kitchen, and the 4 of them remained in the room. Sifiso later came out and gave him 15,000 rand. After 2 days, Sifiso, accused number 5, gave him additional money. In total, he got 45,000 rand. Paragraph 8.7. We mention once again that accused number 2 made the second confession statement on 24 June 2020 to a magistrate in the presence of his attorney. And, my lord, we did mention during the course of the state case, during the course of Brigadier Gininda's evidence, that the defense themselves elicited the fact that there was a Section 105A proposal. This is a plea and sentence agreement.
Is that evidence admissible?
Well, it is not admissible, my lord, but they elicited it.
No, I understand, but I'm saying
Yes,
for
yes,
judicial purposes.
yes. No, it is not, my lord. We
not.
just mention it en passant, that they did elicit that despite the several warnings that we sounded to them, they persisted with that line of cross-examination. But we agree, my lord, that it's hence we...
Except that the court can possibly take note
Yes, yes,
of the allegations, and
Yes.
I'm not making a finding, of the evidence of Gininda,
yes,
saying that Mr. Mjiako was busy consulting with you guys with the possibility
yes,
of
yes,
the
yes.
settlement. He said that.
yes, he did mention...
Yeah, no, I'm just saying.
yes,
People
and
mustn't say I'm inventing the evidence.
yes, and Brigadier Gininda said, well, the state said I mustn't testify about
Yeah,
this,
fine.
but the more he said that, the more he was cross-examined on that fact. Paragraph 8.8, the version in both confession statements accord with the version of the state on how the incident happened, as we've mentioned, how it was planned at the hostel, as testified to by Constable Sizuzungu, the day and time when it took place,
Yeah.
how it happened, namely the 2 persons entered the house of the Nxumalos on the date and time, and how he and the accused were present. The accused 3 entered the house, and the latter demanded money and a cell phone in isiZulu. And as we've indicated, this is what the witnesses who were in the house mentioned. Paragraph 8.12, Ms. Zandi Nxumalo and Tumelo Madlala identified accused number 2 as one of the 2 persons who entered the house, and accused number 2 in his confession admits that he was in the house. The witnesses who were in the house testified that the gun-wielding attacker who was in the house had dreadlocks on, and accused number 3 had dreadlocks at the time. It's a fact that hasn't been disputed, as we have seen in Exhibit S. Paragraph 8.13, accused number 2 states in his confession that there was a scuffle between the deceased and the dreadlocked attacker. The witness testified about that. Paragraph 8.14, accused number 2 states in his confession that 2 shots were fired in the house, and the second shot struck Senzo. The witnesses who were in the house testified to this effect, including the ballistic expert. And as we debated earlier on, my lord, that even the pathologist, Dr. Steenekamp, testified about this fact that this was a contact shot. 8.15, accused number 4 states in his confession that Senzo was shot during the struggle.
Not number 4.
No, accused number 2 states in his confession,
Yeah, fine.
in his confessions, that Senzo was shot during the struggle with accused number 3. The ballistic expert and pathologist confirmed that the deceased sustained a contact shot wound. Paragraph 8.16, accused number 2 mentions in his confessions that he was with accused number 1, 3, 4, and 5 during the incident. Then accused number 1 made a confession and pointing out the house of the Nxumalos and where they were dropped off near the hostel. Accused number 1 stated in his confession that they consulted a traditional healer before they committed the crime, and afterwards went back to the traditional healer for cleansing. The traditional healer, Mr. Lionel Zwane, testified that accused number 1 indeed came to see him in the company of other 2 persons whose face he couldn't see. And he mentioned that accused number 1 also at the later stage, referring to the events of the 30th of May, that he came with the police at Eraton, and he identified him as the person who came to consult him in the company of 2 other persons to be successful in their exploits, and came afterwards for cleansing, and mentioned that things went wrong and someone had died. Paragraph 8.17, accused 3, 4, and 5 were arrested on the strength of the confessions of accused number 2, and a firearm was found in possession of accused number 3 in the house where that he rented, and this firearm was connected to the offense in the sense that the bullet projectile that was found on the scene matches that firearm. And the cell phone downloads show that accused number 5 spoke to Kelly Nxumalo on 2 occasions, the 2nd or the 3rd of August 2014 and 15 October 2014, not long before the incident, 26 October 2014. Paragraph 8.18, accused number 3's cell phone records place him in the reception area of Foslores Tower, which services the nearby Basotho Hostel, on 26 October 2014, which is corroborated by Zungu's evidence. Paragraph 8.1, accused 3, 4, and 5 concede that they were together on the 26th of October 2014, paragraph 18.20. It is considered that the confessions statement by accused number 2 constitute hearsay evidence against accused number 4 at this stage. And in light of the decision of Ditako, which we'll refer to in due course, there is no longer any need to distinguish between confessions and admissions. They are both regarded as out-of-court statements, and the term that's used in South Africa is extracurrial statements. The only question is whether the hearsay evidence is admissible at this stage, paragraph 9.
Sorry, is it correct?
Well, in the sense of section 219.
Yeah,
We'll
I'm with
refer
you.
to section 219.
I'm just saying
yes.
that issue is not settled in our law.
Yes,
Remember, there's a huge debate about
Yes.
that Goldstein, my brother, we used to be together in Joburg, the case of State versus Ndlovu,
yes,
Anta Halter, Ditako, and then there's an acting judge, Davis, in the Cape. There's still a debate about whether it's appropriate to accept Section 3
yes.
of the Evidence Act, in the sense that you make a ruling that it's in the interest of justice to admit certain evidence, like you are arguing,
Yes,
even if it deprives an accused person from cross-examining. Are you with me?
yes, yes.
Am I correct that
Yes.
issue has not been settled in our law?
Yes,
Yeah, fine, okay.
indeed, my lord. And as
Yeah.
we go along, we'll be referring to
Yeah?
Himstra, where he says this rigid approach should be jettisoned. In S versus Mulimi, 2006, volume 2, SACR 8, the decision of the SCA at 9 paragraphs B to D, the SCA held that, and we quote, however, while the rule against hearsay was rigid and inflexible, the Evidence Amendment Act 45 of 1988 Act had created more supple standards which allowed the admission of hearsay evidence if it was in the interest of justice. But this runs counter to section 219 that we will refer to.
Yeah. Except that in Canada, the position there, it's static, except that they equate it to our section 35.
Yes,
Are you with me?
yes, the federal rights of the accused.
The rights of a fair trial to an accused, whether it can supersede Section 3 of the Evidence Act.
Yes.
Those reasons which make you decide that it's in the interest of justice to allow certain evidence, despite that fact. I think that the case is what? State versus, not the Canada case, the ones we allude to. It's that case of the robbery of 34 million rands in Natal. You remember the State versus
Is it not this one that...
I think it's Pune.
uh,
Anyway, that
No,
case, what happened in that case, there's a lady who was, an Indian lady who was part of the group which robbed the Fidelity Fund money. They were listening unlawfully so. They were monitoring her calls. They confronted her with the calls to say, we know that you were involved, your husband and so on, they were involved. And then she confessed. And then they said, where is the money? Then she went and showed them the money inside the ceiling. You haven't read that case?
yes. Well,
The writers, it was Mutata,
Yeah,
Mpati, etc. Anyway, fine. But I'm saying, in that case, they say there are instances, like you are trying to argue,
Yes.
where, for instance, the interest of justice, even if that evidence is unlawfully or unconstitutionally acquired, the interest of justice can demand that that evidence must be made admissible.
Admitted, yes.
That's it, yeah.
Yes, we'll be referring to
Okay.
the case of Korashi, which is
All right, Korashi, okay.
in the same vein.
All right.
And paragraph 24, it says, well, we'll start again on paragraph 9. However, while the rule against CSA was rigid and inflexible, the Evidence Amendment Act 45 of 1988 Act had created more supple standards which allow the admission of hearsay evidence if it was in the interest of justice, provided that the reception of such evidence did not surprise the accused. Well, we argue, my lord, that accused 4 wasn't surprised by the evidence. It was dealt with at great length in cross-examination, or come at a stage in the trial when the accused was unable to deal with it. Further, the court had to ask itself whether, in the circumstances of the case, the reception of the hearsay evidence was unfair to the appellants and therefore not in the interest of justice. And having regard to the factors enumerated in Section 31C of the Evidence Amendment Act, the court held that there was no doubt that the admission of the hearsay evidence contained in the first accused's extracurricular statement was in the interest of justice. The statement had been made soon after the accused was arrested. His subsequent disavowal of the statement was correctly found to have been untruthful. Evidence of the contents of the statement had been tendered by the state to explain cell phone records also placed in evidence. These records have confirmed the probative value of the statement, and the tendering of this evidence had come as no surprise to the appellants. They had been able to deal with it inter alia by cross-examining the accused. The court ruled that there had been no prejudice to the accused and fairness of the trial had not been compromised. And that will be our argument in this matter as well, my lord. Paragraph 10, we mentioned that Mr. Bongani Ntanzi, accused number 2, was arrested on 16 June 2020 and made the first statement soon thereafter on the 19th of June 2020. He then made a second statement before a magistrate in the presence of his attorney on 24 June 2020. Paragraph 11. The statement is corroborated by the eyewitnesses as to how the incident happened, his presence in the house, and the gun-wielding, dreadlocked attacker, whom accused number 2 has identified in his statement as Carlos, accused number 3, how the deceased was shot, that 2 shots were fired in the house, which accords with the findings of the ballistic expert, Lieutenant Colonel Mangena, that the deceased was shot at close range, which is again supported by the ballistic expert, and the findings of the pathologist, Dr. Steenekam, during post-mortem. Dr. Steenekam testified that this was a contact shot. A firearm that was subsequently found in the possession of accused number 3 is ballistically linked to the bullet projectile that was found on the scene. The cell phone records of accused number 3 show that he was within the reception area of the Phosphorus Tower on 26 October 2014. Accused number 3 and 5, out of their own beds, concede that they were all together on the 26th of October 2014 in the vicinity of Phosphorus. Cell phone downloads show that accused number 5, whom accused number 2 mentioned in his statement, contacted Kelly Nxumalo on the 3rd of August 2024 and 15 October 2014, paragraph 12.
So,
We therefore, yes,
I'm just thinking wildly. You are saying accused 2, 3, and 4 admit that they in the vicinity. Is it 2, 3, 4, or what?
no, it's 3,
3,
4,
4,
and 5.
and 5.
Yes,
They make the concession
yes,
that they were within the vicinity.
yes. They say they were having fun traveling in a combi.
Yeah, fine. I'm just thinking because the charge sheet says at or near. People don't interpret that. Just read the charge sheet. It says the offense happened at or near Phosphorus.
Yes.
Just read it. It doesn't say it happened at Phosphorus. Let's read it so that this ghost can jump off my back.
We'll just retrieve,
Yeah, just read. It says what?
retrieve the
Yeah.
in indictment.
Dr. Sibanda.
The first count is that in that upon or about
Yeah.
26 October 2014 and at or near
Yeah,
Phosphorus.
that's it.
Yes, at or near Phosphorus.
So that argument or that citation is wide. At or near Phosphorus.
Yes,
Okay, I'm just thinking aloud.
indeed, as the court places. I think when page 25, paragraph 12, we respectfully submit that there is therefore corroboration for the extracurrial statement of accused number 2, and that the high probative value and objective guarantees of reliability alluded to in Glovis' case, which we'll refer to briefly, are as compelling a justification to allow hearsay evidence are present, and we have already mentioned the fact that even the defense themselves put on record that accused number 2 had proposed a section 105 paragraph which eventually fell through, paragraph 13. As a starting point, section 219 of the Criminal Procedure Act prohibits the admission of a confession against any person other than the maker. It provides that the confession of an accused cannot be admissible against a co-accused. In paragraph 40, in essence, this section envisages that no one may be challenged on another person's confession. Thus, evidence obtained from the confession of a co-accused will affect only the confessor. We've referred already to the case of Mulimi and we refer to the case of Libazi, 2010, Volume 2, SACR 233, the decision of the SEA, S versus Bartman, 1960, Volume 3, SA 535A, S versus Robe. I think my colleague has referred to these cases yesterday, 1968, Volume 4, SA 420A. Paragraph 15, the general rule in South African law provided that confessions and admissions of a party were evidence against him or her only. At common law, the extracurrial statement of an accused was inadmissible against a co-accused stemming from English common law, and we refer to, I think my learned friend also referred to this case of the House of Lords in R versus Hayter, 2005 to all law reports ER 209 2005 UKHI 7, that out-of-court confessions made by a defendant are admissible against the maker, but as a general rule are not admissible against anyone implicated in the confession. And interestingly, my lord, I think I read in one of the cases that the reason behind the rule was that the police force in the UK was not that well trained, if I remember, and that this was now used as a precaution. But in our environment, the well-trained officers such as Brigadier Gininda, that motivation will fall away. If confessions and admissions are proffered as proof of their content, such as in cases where they are used against persons who did not make them, they are hearsay. Certain exceptions existed in respect of admissions pertaining to various admissions and common enterprise, while Section 219A regulates the admissibility of admissions. The Criminal Procedure Act regulates the admission of admissions. It does not provide a direct statutory prohibition for admitting extracurricular admissions of a co-accused as evidence against another accused. A prohibition existed under common law whereby the courts were encouraged to exercise a cautious approach in dealing with them, in terms of which that in respect of admissions, they could consist of hearsay evidence only in discrete situations when such situations provide proof of the ongoing conspiracy, or executive statements, as we'll refer to in due course. Such so although confessions could only be admitted against the maker, extracurricular admissions could be presented to the court against any person implicated by the maker, even when the maker chose not to testify or disavowed the statement. Paragraph 16, we refer to the case of State versus Ndlovu, 2002, Volume 2, SACR 325 SCA, where the state invoked Section 3 of the Law of Evidence Amendment Act 45 of 1988 to have informal admissions of an accused person admitted in evidence against a co-accused. The SCA held that extracurricular admissions could be allowed within the prescripts of the Law of Evidence Amendment Act, thereby replacing the common law rule that an extracurricular statement by an accused is admissible against a co-accused. But we know, my lord, that in the case of Mhlongo, which we'll refer to in due course, this fact or this finding was overruled. In Ndlovu's case, the SCA held that extracurricular admission, but not a confession by an accused, is admissible against a co-accused if the requirements of Section 3 of the Evidence Amendment Act dealing with hearsay evidence are satisfied, no constitutional principles are offended against, and it is in the interest of justice to admit it. Paragraph 17, we point out that the legal consequences of the Ndlovu judgment was that although confessions could be admitted only against the maker, extracurricular admissions could be presented to the court against any person implicated by the maker, even when the maker chose not to testify or disavow the statement. This also implied that a co-accused who had been implicated in an admission by another accused could be found guilty on the basis of such a statement, even when the maker distanced himself from making such a statement. Therefore, the co-accused so implicated will be required to challenge the admissibility of such a statement under the hearsay rules. Then in paragraph 18, we refer to the case of Ditako versus the state, and Ditako is spelled Litako versus the state, 2014. I'm told that this will be an appropriate time to take the normal short adjournment.
Okay.